Emma, thanks very much, and indeed everybody from your organisation who are tuning in today. We have just, that's Emma and I with Helen, just had a very brief 1-minute chat about how we might approach this lunchtime session with a view to trying to make it as engaging and helpful for you as members. Economic and social rights do raise obvious questions for anybody who's a lawyer or a human rights lawyer, almost immediately, and that's perfectly natural. And they're not always conceptually that easy to comprehend because they are a bit different in some ways from perhaps some of the rights you're more commonly used to referring to, like freedom of expression, or for example, right to life, or right to be free from torture or inhuman treatment. But they're not that different, and fundamentally, in many respects, they're very much the same. But in the course of this session today, it's very much open to you to ask questions. It's going to be quite a basic session, but even dealing with some of the basics requires, I think, some deeper thought about what do we really mean about rights in this context. How can you have positive rights that require states and governments to make provision, material provision for people? How does that work in our sort of modern society and our modern view about how we arrange, and organize ourselves in our societies? And so, I definitely want to try and get into some of that stuff a little bit, if only just to stimulate your thoughts and maybe some questions, but at the same time, just give you a little bit of the kind of basics and the background so that you can start to talk and think about these rights more freely. A little bit about Just Fair, just before we start. Just Fair is an organization that was started in 2011. It was started really because we being those who were involved in starting it in 2011, observed that there was really a bit of a gap in human rights protection fundamentally, but also in terms of the human rights community when it came to economic and social rights, which, as we'll see in a moment, are a long-standing aspect of our modern conception of human rights. It also was started at a time where there was a perceived threat to the enjoyment of those rights in the UK. We just had the financial crisis and the fallout from that, and we were about to commence a programme of austerity, which many people who were concerned with human rights appreciated was likely to have an impact on the enjoyment of rights. It almost couldn't fail to do so. And that raised important questions about how a rights-based approach could interact with what was fundamentally a political or economic programme designed to overcome the stresses caused by the financial crisis. Just Fair, as I say, was then set up at that time, and we generated an overwhelming response. We really were quite taken aback. Our first event, we had a 2-day conference at the Law Society where we were massively oversubscribed. We had a lot of international speakers because, again, as we'll come on to see, these rights have been perhaps slightly better developed abroad than they have been here. And so there were people who were able to come to this country and talk about what it meant to have these rights as part of their constitutions and as part of their legal framework generally. And it was a very sort of enlightening and educational experience for us. And since then, we've seen, the momentum behind economic and social rights really grow quite considerably, not just in the UK, of course, but also further afield. And indeed, as the UK, and we'll again come on to look at this a bit in detail, develops the momentum behind other countries which are already further ahead. Those other countries have, of course, continued with their own journeys, and we are now seeing many other countries incorporate these rights directly into their constitutions, or we've seen their legal actors, be it judges or others, start to develop these rights and treat them as an established part of, if you will, like their legal architecture. So for those lawyers who are concerned about issues around poverty, for example, and how the law might interact with poverty, it really is pretty critical to have an understanding about how economic and social rights operate, what they are, and how we've come to be where we are in relation to their overall momentum. What I would say is, going right back to FDR's declaration about, the four wants, etc., and then that ultimately leading to the Universal Declaration of Human Rights, is it's critical to understand that what is sometimes now talked about as a division of rights between civil and political rights and economic and social rights was not how they were conceived originally. It was always understood that you had to have both sets of these rights in order to have a full, as it were, collection of the necessary rights to ensure human flourishing. So the division between civil and political rights and economic and social rights, of which I'm sure you're all familiar, really developed after the Universal Declaration. And of course, the major geopolitical event that happened in the decades thereafter was, of course, the Cold War, and an ideological split between the West on the one hand, which was very, agnostic would probably be a kind way of describing their approach to economic and social rights. They were not opposed to them, because as we'll come on to see, the vast majority of Western countries, including the UK, ratified the UN conventions around economic and social rights. So they didn't oppose them in that way, but they opposed them in the sense that they weren't considered to be equal rights to civil and political rights, because they weren't rights that we as individuals were able to enjoy and enforce directly against the state. Whereas, of course, the East in the former Soviet bloc took a slightly different approach. They tended to favour rights which focused on material prosperity, material goods, and equal distribution of those, and perhaps had less focus on civil and political rights, which had more to do, of course, with democracy and democratic accountability, such like. What that meant was ultimately, just trying to make these move. What that ultimately meant is that we ended up with two UN covenants. We have the covenant, as I've already said, on economic, social and cultural rights, and we have the covenant on civil and political rights. And both of those were agreed ultimately in the 1960s, 1966, and have been ratified and were ratified by UN state parties thereafter. And as you can see there, Great Britain and Northern Ireland ratified ISESCA, which is how it's commonly referred to. That's the International Covenant on Economic, Social and Cultural Rights in 1976. And now in the formal structure of these two covenants, there is no disparity or inequality between their legal force. They are both considered to be of equal force, but that hasn't been mapped out on a regional basis. And certainly in the region that we're all in at the moment, or at least I think the majority of us on this call are in Europe, they haven't been given equal status. So we see that in a very formal way at the Council of Europe. So at the Council of Europe, you've obviously got the European Convention of Human Rights, which, as you know, is a set of directly enforceable rights at the European Court in Strasbourg. And then you've got the Charter of Social Rights, which is, or the Social Rights Charter, I should say, which doesn't have a sister court to the court in Strasbourg, but does have the European Committee of Social Rights, which approaches these rights in a slightly different way, not so much by individual enforcement, but by mostly collective action. And the UK is, in fact, a signatory of the Social Rights Charter, but has not signed up to the Collective Rights Protocol. So you cannot bring collective complaints, as they're described, against the UK. But for example, Ireland has, France has, and other countries have, and you can see how those collective complaints map out. And I'll talk a bit more about how you adjudicate or litigate around these rights in due course. What we do have at the UN level is, what is effectively a expert committee which presides over the implementation of ISESCA. Now, that's not a method of implementation which is unique to ISESCA. There is also a committee for various other UN human rights committees, conventions that you will have heard of. So you've got obviously the Convention on the Rights of the Child, UN Convention on the Rights of the Child. You've got the UN Conventions on elimination of discrimination against women, elimination of racial discrimination, and then on the rights of disabled people. And all of those all of those conventions, not covenants, there's only two covenants, that's ISESCAR and Civil and Political Covenant, but each of those conventions also have their own committees. And those committees at the UN level basically fulfill three core functions. The first is they provide sort of authoritative guidance on the content of the rights. Now, economic and social rights, much like all the human rights that you'll be used to looking at, are expressed, of course, in very broad terms. They require further adjudication, deliberation, and jurisprudence in order to understand what they mean in real terms in practice. And the principal means by which, at the UN level at least, that is done is through the production of general comments. So these are comments produced by the committee in an advisory form, or committees in an advisory form, which are then utilised by judiciaries around the world and other policymakers to better understand effectively what the current understanding is in relation to a particular right. And I stress that word current, because what we've seen over time, and of course this is very familiar to anybody who's looked at human rights jurisprudence, is that these rights evolve and develop according to the social mores at the particular time, and competing, as it were, stakeholders who all have perhaps different views about exactly how these rights should be adjudicated upon. And that means these general comments are periodically replaced as well with more up-to-date versions, which tries to reflect, as I say, the kind of living nature of a lot of these rights. The second core function of the committees is that they review state party compliance with the covenants or conventions. And how that is done in very general terms is that there are periodic reviews which take place roughly every 5 years, where each country must submit to the jurisdiction of the committee. That is a rather strong way of putting it. I mean, the reality is that because this is all happening at this stage, at least on the international field and on the intergovernmental field, there is no binding effect from the findings of the committee on these periodic reviews. But nevertheless, they are given very considerable weight and have considerable force in various other arenas. But those periodic reviews, as I say, take place every 5 years. We'll have a very brief look a little bit later about how they actually happen and the processes, but that's just for your understanding about this second core function. And the third one is that some of the committees, including the ISESCAR committee, now have a form of direct complaint or communication available. So individuals or groups of individuals can bring complaints about state party compliance. So ISESCAR actually produced its complaints procedure through an optional protocol to the covenant, which the UK has not signed up to, but many other European countries have. And indeed, we have already started to see quite a number of complaints be processed by the committee. The optional protocol only was ratified, I think, Helen might know the detail on this, about a year before, I think, COVID, maybe slightly more than that. And I think COVID has generally impacted upon the functioning of all the UN committees, but has also impacted on the ability of ISESCAR to run through these complaints speedily. So we're only now starting to see some actual decision-making, as it were, from the committee on these individual complaints, which does involve the committee giving effectively binding decisions, because those countries who've signed up to the optional protocol have agreed to that, which can include remedies being made available to individuals. So you can find further detail about ISESCAR.
Sorry, Jamie, I was just going to jump in quickly, because just to give like a, it wasn't SESCAR, but Jamie mentioned the Committee on the Elimination of Discrimination Against Women, and just to show you some real life application, it was an inquiry by the CEDAW committee that actually led to the UK government changing the law in Northern Ireland in relation to access to termination of pregnancy. So although, as we talk about, it's not binding, that's the huge force of it and the huge moral force it has. So like, that's a real life result that you see, the change in legislation in Northern Ireland to become human rights-based was because of the CEDAW committee.
Yeah, I think that's a very good point. And there have been various other similar examples, in fact. So you may recall a few years ago that the UN Committee on the Rights of People with Disabilities conducted only its second ever, as it were, self-initiated inquiry into state party compliance, and it was in relation to the UK because of what was perceived to be a set of very regressive policies in relation to disabled people's rights. And many people say that inquiry, which again didn't have any binding force as such, but made quite a significant impact on the media narrative and the policy environment around disabled people's rights, was at least partly responsible for reversing some public opinion and ultimately political will around the austerity programme. And as most of you will now be familiar, this government has eschewed any attempt to reintroduce austerity as a response to the fiscal crisis, or difficulties, one might describe it better, caused by COVID. So yes, they do have, as Helen says, really quite significant weight and force, even if you're in an environment like the UK currently is, where these rights are not in fact directly enforced. But how long that will remain the case is the big question. So let's just have a very, very quick run through of the rights in ISESCA. This is just a brief description. There is obviously a bit more to be said about each of them if you ever chose to look at them, but you'll see the kind of basic areas that they cover. I'm just going to start here on Article 6 and then come back to these ones, Articles 2 and 3, in a moment. Right to work, just and favourable conditions of work. Now those rights, Article 6 and 7, are potentially, and this is somewhat controversial, the least developed of the rights under ISESCA. And the right to work is one which has a potential to be, I suppose, the most political out of these rights, because it does ask then questions about what the state's role is in ensuring that people have work available to them. Less so 7, because of course there's a huge international framework of agreements around what the just and favourable conditions of work might look like, and of course the ILO plays a more prominent role in that, as with Article 8 and unionisation. But these rights here are perhaps the rights that are more commonly talked about, or most frequently referenced as social rights rather than necessarily economic rights, and are perhaps the ones that are most sort of well developed under this particular jurisprudence. First is the right to social security, which is the right, of course, to have some kind of system in place in any state which will ensure that you can meet your minimum needs in the absence of being able to work or otherwise access your own resources. Family assistance is closely related to that, but that's about positive provision of support principally to mothers to ensure that mothers and babies are looked after, and also that you have the support necessary for family life in a positive sense rather than negative sense that we're more familiar with in the context of Article 8. Then Article 11, which is about adequate standard of living, of course, is very important. And we'll talk about a bit more about what the content of that right is in due course. But essentially that is speaking to ensuring people have the material conditions necessary to live fulfilling lives. And then the right to the highest obtainable standard of health, which is Article 12, is of course a corollary of that, although of course equally has independent and autonomous meaning. And the right to education is straightforward enough. And then cultural rights, which are often the kind of somewhat forgotten aspect of this covenant, but they're actually incredibly important, arguably more important these days than ever before, because they have to do with cultural participation. And that then focuses on things about identity to some extent, but also upon sort of modern forms of interaction. So there is a real burgeoning enthusiasm and momentum around the right to the internet, for example, and the access to digital literacy, which is being developed under Article 15. So those are the kind of the brief rights in a nutshell. As we've already talked about, these are rights which the UK has signed up to and ratified, and therefore, in principle, they're rights which are enjoyed by everybody in Great Britain and Northern Ireland, and that would apply irrespective of their legal status, i.e. their immigration status. It's by reference of being here that these rights apply. And the duty bearers are central and local government, so there isn't horizontality in the same way that there isn't under our European Convention. We don't enjoy these rights vis-a-vis one another, but they are rights that we enjoy vis-a-vis the state. And the chief obligation is to, just as it is with civil political rights, respect those rights. So that means that the state can't directly interfere with an individual's enjoyment of those rights, protect those rights. That makes sure that the state has to regulate in order to ensure that third parties can't interfere with the rights of individuals, and then fulfill those rights. Now, of course, in the context of civil and political rights, sometimes the fulfillment of those rights doesn't require the state to do very much more than respect and protect them. But in the context of economic and social rights, there is a more slightly burdensome, I should say, question about what does fulfillment mean. And I just want us to go backwards a little bit here now to this list of rights and look again at Articles 2 and Articles 3. Well, most importantly, this one, Article 2.2, makes sure that there should be equal treatment in respect of these rights. So there should be equal enjoyment of these rights. Now, in the context of material possessions, this obviously has significance. Does this mean there should be equality of outcome as opposed to equality of opportunity? Well, no, it doesn't go that far. But it does mean that in the context of the distribution of material goods, if there is going to be any difference in treatment between people of different cohorts or different classes or different protected characteristics, then those differences need to be substantively justified. But Article 2.1 is the one that really is different from any equivalent in the Civil and Political Rights Covenant. And it does not have a sister right in that covenant. And Article 2.1 essentially guarantees that the state must make available the maximum available resources in order to ensure progressive realization of these rights. Now, Article 2.1 was a very important negotiated aspect of the covenant because it was recognized that not every state in 1966 or thereafter in 1977, when it was ultimately ratified, was in an equal position to guarantee enjoyment of these material rights for the people living within their territories. It was, of course, recognized that in some places there simply weren't the resources available to ensure that happened, certainly not resources that were available to the state. And therefore, in order to ensure that this covenant still had meaning, this obligation, Article 2.1, ensures that whatever resources are available are identified to the maximum extent and then utilized to the maximum extent to ensure enjoyment of these rights. And if you think about it, that's really not saying very much more than trying to ensure that the state is in a position to redistribute to the extent necessary resources to ensure that to the extent necessary, everybody living in a particular country can access these basic material resources. Why? Because, of course, the underlying philosophy here is that absent these resources, people cannot live fulfilling life, even if they live in democracies where civil and political rights are otherwise available to them. Now, the adjudication of Article 2.1, of course, is not straightforward, and you won't be surprised to hear that. And the general comment on Article 2 makes for very interesting reading. But some features of it that you may find are interesting and something we might want to talk about is, for example, there is some discussion in the general comment and in the jurisprudence of the committee about the obligation to ensure that states have transparent tax policies, that states do all that they can to clamp down on corruption, particularly in the context of tax policy. There's an obligation to try and ensure tax policy is to some extent progressive rather than regressive. So, for example, if a state was to only seek to raise general taxation through value-added type taxes, i.e. taxes on everyday goods, as opposed to having any kind of progressive income tax system, that might be considered to be questionable under Article 2.1. Similarly, whilst the general comment is absolutely clear that the covenant itself doesn't presuppose or prescribe a particular political system, it doesn't say, and how could it if it was going to remain a legally neutral document, that you must have a social democratic system, or you must have a laissez-faire market-orientated system, or you must have a system which is primarily based on state control. It doesn't say any of those things, but it does say that in order to ensure people can adequately access those legal systems, people have to ensure some basic minimum material provision. And then moreover, on top of that, there are certain process-based rights about transparency and what one might describe as kind of strategic planning even if it's not planning which is all predicated upon the state being the sole provider, but at least you ought to have a plan for ensuring how the private sector will, for example, ensure there is appropriate housing available for people, or you ought to have a plan which ensures that the price of food doesn't mean that you have very considerable food insecurity within your state. So it's not just a process about saying, okay, you enjoy these rights, therefore you have a substantive right to something material in your hand. They're also a set of process-orientated rights which accompany these substantive rights, which are designed to ensure that governments have clear-cut, explicit plans which can be adjudicated upon and ultimately can inform those who are exercising their civil and political rights in the democratic domain to try and enhance enjoyment of these material rights. Another very important part of the jurisprudence around Article 2.1 is the principle of non-retrogression, which is effectively to this effect, that state parties should not deliberately pursue measures that they know will result in a regression in the enjoyment of these rights, so something the opposite of progressive realization, but retrogression in the enjoyment of those rights, unless very strict criteria are complied with. And one of those strict criteria has been identified in the past as being where the state party is experiencing some kind of fiscal moment, some kind of fiscal distress. So when we talked earlier briefly about the setting up of Just Fair in the context of austerity, of course, austerity wasn't only happening in the UK, it's happening in many other countries around the world in response to the financial crisis, particularly in Europe. And therefore, the UN Committee was very active at that time in trying to remind state parties that in times of financial crisis, it wasn't as if human rights were to be discarded and put to one side. On the contrary, this was exactly the time that they were to be utilized. You know, the famous expression that human rights were built in crises and for crises, and that's exactly the point. And so the UN committee was very keen to remind state parties that if they were going to adopt these programs of austerity, that they should be time limited, that they should be only regressive to the extent strictly necessary in order to ensure the general well-being of the country. And they should always guarantee absolute basic minimums of material goods for people so they can enjoy these rights to the minimum extent necessary to ensure compliance, and that there should be non-discrimination in these programs. Now, I raise all of that for the purpose of just giving you another example of the practical impact of all of these rights. So the last UK review was in fact in 2016, and Helen mentioned that a moment ago at the outset, and I'm not sure if we'd actually started the session then, or it was just when Emma and I were talking with Helen. But that's when Helen and I first met. We were both participating in the periodic review, which was taking place in Geneva in 2016. And the big topic was, the state's approach to austerity, which we were kind of 5 years in at that stage. And the evidence was starting to demonstrate some rather worrying trends, amongst which was that, despite the sort of political rhetoric at the time, we weren't all in it together, but certain particular groups had been hit very, very hard by the austerity program. Indeed, there were some of the groups that had already experienced disproportionate levels of poverty. So disabled people, for example, were chief amongst those groups. Also, other people who'd already experienced significant economic deprivation in the past were facing a particularly heavy burden through the austerity agenda, and that wasn't just in the form of cuts to social security payments, but also in terms of the very significant cuts to local authority budgets, which then affected various other programs, including social care, etc. And we ultimately did persuade the UN that the UK government was in breach of many of those obligations, despite the government's protestations that wasn't the case. And ultimately, the UN produced a report in 2016, which was based on reams and reams of evidence and 2 days of hearings in Geneva, which said that it did appear that the UK government was in violation of its obligations in relation to how it had conducted its austerity program. And it was another aspect of, as it were, a kind of the legal response to austerity, which I think ultimately was a very key component of discrediting austerity. I mean, I think austerity now has been widely discredited by the IMF and others as being an economically illiterate approach to the financial crisis that actually extended the period of recession and negative growth or limited growth in response to the financial crisis, and has been kind of jettisoned. So it was very important that the human rights community played a role in all of that, because of course austerity wasn't just a bad economic policy as it transpired, it also had very real impacts for people living in poverty, in the sense that it exacerbated their poverty, and we are still to some extent experiencing some of that today. So yeah, that's just an example of how, or an attempt to give you some context about how Article 2.1 interacts with these other rights, which if you didn't have Article 2, these rights might seem to be more, aspirational more than anything else. Well, of course, everybody in theory has a right to work. Everybody in theory ought to have a right to an adequate standard of living, but the resources aren't always available, particularly in some countries. How are states supposed to react to this? Is it just going to become a sort of dead letter? Well, Article 2.1 ensures that isn't the case, because Article 2.1, as I says, well, whatever resources are available need to be accessed to the maximum extent and utilised to the maximum extent to bring whatever enjoyment you can to these rights. There are then a whole host of other process-based obligations on the top of that, which ensure transparency and ought to inform the democratic process. They also ought to some extent, eliminate the scope for corruption. And then on top of all of that, a political agenda which seeks to take steps that are retrogressive in the enjoyment of these rights will prima facie be in breach of the covenant unless you can justify it through these very strict tests.
Just to jump in, Jamie, we Just Fair will actually have a blog up later this afternoon to look at how the proposed cut to universal credit represents a breach of international obligations, mainly around SESCR and progressive realisation. So I can send that on to Emma to send around.
Great. Well, that'd be another good way of people just sort of getting their head around some of these issues. And I'm conscious that if you're completely new to this, I'm going through it very fast. It might be quite difficult to digest it all. But there are, there's a lot written about all of this. There's an awful lot of material out there. It's a very well developed aspect of the UN's functioning. And so for any of you who are interested in it, there are probably other ways in which you can pick up that interest and read into it very easily. And of course, Just Fair will help you with any of that as much as we can. What I'm now going to just talk a bit about, though, is the treaty review process, which I've also just mentioned, if only just to reinforce the point that even though we are not in a situation yet where these rights are binding, and indeed the findings of the UN committees, which are called concluding observations, don't have any binding force in the UK, in the sense that we as individuals can't enforce them. They do have huge moral force, and they do have great strength in terms of assisting civil society lobbying and advocacy, which for you guys is something which you'll need to know about, because Lawyers Against Poverty will need to know about all the tools available to use the law to try and tackle poverty, and whether or not that's in the UK or, as I think you're more commonly involved in situations abroad, because the vast majority of countries are, of course, signatories to the now ratified covenant, and therefore will be going through this process. But leaving that aside for a moment, there is actually, no, let's just do a bit on the cycle here. So this is just a little quick bit about how the review process actually works. You start off with a state party submission. So that's the government effectively saying, look, this is how wonderful we are. These are all the great things we're doing to comply with the covenant. They go through each of the rights and they say, look at all these great policy initiatives, and you can see all the stats are going in the right direction. We're all wonderful. There's nothing to see here. And then you have a list of issues developed by the committee itself, which says, okay, well, there does seem to be some aspects here that we'd like to look at more closely, because as you can see, the covenant has incredible breadth. An awful lot of issues could potentially fall under its jurisdiction. So the committee necessarily has to focus on some discrete issues. Then you have a response to the list of issues. Now, that response will come both from the government and indeed from civil society. Civil society organisations can say, well, actually, we're not sure the list of issues really covers everything that we think is of concern in the particular state party at the time. And then ultimately, you will have consideration of the state party report, i.e. the review itself, where the committee will make its concluding observations about levels of compliance, and we'll see those there. What isn't, sorry, in this slideshow very clearly is that civil society themselves will respond at each of these stages, but most importantly, we'll provide what's called a parallel report or a
I think if you click on, it'll come in. Sorry.
Oh, sorry, my mistake, Helen, sorry. Helen prepared these wonderful slides, not me. So, yes, so here we are. Sorry, this is what civil society will then do. That's our parallel report. And for any of you, if you're interested, you can see the Just Fair parallel report that we submitted in 2016, which was a very comprehensive document, which went quite a long way, I think, to persuading the committee that the state's representation of what was happening in the UK was an incomplete picture. That parallel report then is considered, as you see, as part of the review, and also submissions on the list of issues will be made by civil society, as I mentioned a moment ago. Then attending the first session, which is where the list of issues is devised and settled upon, and then you might provide an updated version of your parallel report if the list of issues change. Then you attend the review itself in Geneva, which is what I was talking about earlier when Helen and I met. And then you may have a shadow follow-up report, which deals with what's happened in the state party since the concluding observations were reached. And that is the point. Civil society can then use this authoritative statement from the UN about the level of compliance in all of its advocacy work back in the host country to try and affect social change. Okay, so what I wanted to talk about briefly before I stop and open up for questions, because it's gone a bit longer than I planned, and I'm sorry about that, is that moves are, however, afoot to change the level of appreciation and enforcement of these rights, not only in the UK, but internationally. So at the moment, as I say, this, from the UK perspective anyway, has been operating on the intergovernmental plane only and at the UN, but that is changing. In particular in Scotland and Wales, who have taken very significant steps to now have enforceable economic and social rights contained within their legal systems. They have principally been done through the rights of children so far. I mean, my interpretation of that is that's much more palatable to people who might be resistant to the idea that you could have enforceable economic and social rights. You say, well, let's at least start with children and make sure that children's rights are enforceable. And the UNCRC, so that's the UN Convention on the Rights of the Child, does contain not only civil and political rights, but economic and social rights. And they are likely to become law in Scotland before too long. There's a small battle going on in the Supreme Court at the moment between the UK government and the Scottish government about whether or not the Scottish government actually had, under its devolved powers, the ability to enact the UNCRC Incorporation Scotland Bill 2021 so as to make these rights enforceable. But assuming the Scottish government is successful in that regard, then those rights will become directly enforceable to individuals in Scotland, and that will mean the courts will need to adjudicate upon them. Similar steps are underway in Wales, although the approach in Wales is slightly different. I think it's more of a due regard duty, which is so that policymakers must have due regard to the rights contained in the UNCRC when making decisions about individuals. And of course, that due regard duty is an enforceable duty as such. And here we just have a bit more detail, which I'm not going to go through at this stage, about the Scottish bill, but you get the general idea. This would be a very significant development. But of course, it would not be unique to Scotland. Unfortunately, the way I've created this slide is I had some text underneath it, which of course won't actually show up on your screens. But here is a list of some countries who have incorporated these rights directly into their constitutions. There are, in fact, a whole host of other countries who have done it in slightly different ways. So, for example, Germany and France haven't incorporated the covenant directly itself, but they have a host of economic and social rights which are directly enforceable. So the right to housing, for example, in France is a directly enforceable right. So is the right to various other economic social rights in the German constitution, all coming under the umbrella of the right to dignity. Other countries have incorporated these rights in a slightly different way into their constitutions so that they are treated as kind of aspirational rights or interpretive tools. So all the other rights are interpreted through the prism of those rights. and others have seen these rights come to force through judicial activism to some extent. So we've certainly seen a lot of that in South America, in Colombia, and in Brazil, etc. And equally, there are a whole host of other countries who are doing things very similar to what Scotland is doing at the moment, which they're currently in the process of developing their own economic and social rights charters or constitutions. All of which, you can't necessarily get this from a slide, and I appreciate that, but all of which is very much testament to the fact that we are over the Cold War now, a long time since over it. We've had, an era where we've had a dominant political ideology or political economic ideology in the form of neoliberalism. There is some degree to which I think there's a recognition now that there needs to perhaps be some constitutional protections of things like welfareism, social security, etc. And we need to have some power given back to states to ensure that individual citizens are able to enjoy, to the extent necessary to protect their rights, the material gains achieved through economic development and growth. And it's becoming a very conventional way of understanding how human rights interacts with the economy and politics. And indeed, if anything, we're now in a phase where the chief criticisms of the human rights movement aren't coming from sort of liberals who say, well, there's no such thing as a right to housing or a right to an adequate standard of living. It's much more coming from those who say that the human rights agenda hasn't done enough since 27, 28, the economic crisis, and then through COVID, to protect people, and that the human rights community is at risk of becoming irrelevant, really, if it doesn't suitably protect these rights alongside civil and political rights, because of the deep understanding that they are indivisible and cannot be enjoyed independently of one another. And certainly that would be the view of Just Fair and many others, that this is definitely the direction of travel, and it's only a matter of time before we see these rights enforced, not only in some of our European neighbours, but also in the UK. And of course, the EU already has the Charter of Fundamental Rights, which contains quite a lot of economic and social rights, which the UK has recently lost through Brexit. So there's even more opportunity, one might say, and need to do something about the state of these rights within the UK. And the final observation I'd just make about all of this is, I'm not quite, and I'd be interested to know what, LAT's trustees and members think about this, but where actually a lot of this momentum came from behind economic and social rights initially. So not so much the recent momentum, which is sort of post-financial crisis, but really in the late 21st century, is that it really came, late 20th century, it really came through the development movement. And the development movement working in the Global South realized that they needed a framework of norms that they could rely on to try and measure and advance the cause for development, which was otherwise stuck in a kind of aid-based approach, which of course didn't ensure sustained enjoyment of the material conditions necessary for people to prosper independently. And it's interesting to my mind that a movement that was based on international norms really fell upon this pre-existing framework in the form of the covenant as being the best way to articulate those demands. And we are now seeing that progress all the way through into the global north and into developed countries, where recent events, including the global financial crisis and COVID, have inspired a similar response, including a response from the legal community, and particularly those lawyers who are interested in seeing the eradication of poverty. So that was a whistle-stop tour through a number of reasonably complex subjects, but I hope it gives you a feel for some of it. Helen and I are now available to answer any questions you might have, or we can just have a general discussion, observations. What does all this strike you as meaning? Does it seem like something you need to know about for your work, or does it seem something too abstract to be relevant? Do you have burning questions about how this can actually work in practice? Do you have questions about where we are politically on this in the UK? Where do we see there might be scope for change, etc.? we can do our best to address any of those questions or observations such as you may have. Whilst you're all scrabbling around to come up with those questions, you should probably know that the next review, and I'm sure this is in the slides, is coming up in 2023. Just Fair is likely to play a prominent role in representing civil society as part of that review. And that's something which our respective organisations may wish to discuss going forward, because of course there's always a role to be played, and we also are very keen to try and ensure that there's as much legal expertise available to help other organisations put together their submissions, so that we can collate them and really put forward another very powerful submission to the UN committee. I really would recommend, if any of you have a chance, and I'm sure Helen can provide a link, a look at Just Fair's submission in 2016 to get a sort of feel for what we're talking about, what this all means in practice when you're looking at a specific case study, in that example, of course, the UK.